Welcome to Criminal Law 101, Video 3, Mens Rea Part 1. My name is Stephanie Ledesma, Associate Dean of Experiential Education, Professor of Law, and Attorney at Law. And what we are going to journey into today is Mens Rea. We start this journey into the criminal mind by reviewing criminal liability formula. Again, this is the formula that I've contributed to the criminal law discourse. We see that we started with actus reus. We've moved from actus reus now to mens rea, but here's a practice note. Mens rea is oftentimes absent in the statute that defines or identifies the law if it is a strict liability crime. That was a pause for you to take it in, but just keep it there. Strict liability crimes will be addressed in a different video. For the purpose of this video 3, Mens Rea Part 1, we will not address strict liability. Now, let's turn our attention to the guilty mind. For all of you who understand Latin, who speak Latin, who appreciate Latin, here's a little bit of Latin. Actus reus non facie, reum nisi mensi rea. An act is not a crime without a guilty mind. Say it one more time. An act is not a crime without a guilty mind. Usually, as we enter into the world of mens rea, we notice a significant difference between common law categories of mens rea and model penal code categories of mens rea. No, common law has many more categories. In fact, the common law had up to 80 categories of mentis res. We are going to be focused on the 4 categories that are listed in the Model Penal Code, section 20201. But whether you're in a common law or in a model penal code, this statement that I'm about to make is a truth. General wickedness is never enough. General wickedness is never enough. I introduced in the previous slide the 4 categories that are identified in the Model Penal Code. Let's define those categories briefly. And when I say briefly, on this slide, with all of these words in bold, some of them in red, some of them in blue, some of them in black, don't get lost or overwhelmed in what appears to be a lot to try to digest. For the time being, what I want us to pay attention to are the words that are bold in blue. So for the time being, what we are paying attention to is, for purposeful, we're looking to see if the actor is acting with a conscious objective of engaging in that particular behavior. Is the actor acting with a conscious objective to engage in that particular behavior? When we move to knowing, focus on, is the actor acting with practical certainty that his behavior will yield what he wants his behavior to yield. Practical certainty is knowingly. As we move down to reckless conscious disregard of a substantial and unjustifiable risk. Reckless is a conscious disregard of a substantial and unjustifiable risk. Negligent is you are aware, the actor is aware of a substantial and unjustifiable risk, right? Nuanced, hugely important. This is not the time to interchange words. This is not the time to speak very loosely, right? This is the time to be concise and precise. Concise and precise. So let's stay true to our current methodology where we are introduced to a legal concept, and then we go to a case or two or three to get a better understanding, right? To develop some level of competency of that legal concept. What's been introduced? The legal concept of mens rea. Specifically, we've looked at the 4 categories of mens rea that are identified in the Model Penal Code. Even more specifically, we've looked at purposeful versus knowing versus reckless versus negligent. Okay, let's explain what those words mean. Because on a page, that's all they are. On a page, they're a theory. On a page, they are a concept. They are an idea. It is not until you breathe the breath of life into the words that they have any relative meaning in our society. So let's take a very old case, but a relatively simple case that is perfect for introducing the concept of the different levels of mens rea. That case is going to be the Regina versus Faulkner case. Regina versus Faulkner. It's an 1877 case. Sure, no case, but it gets the job done, right? So just because it's old doesn't mean that you put it out to pasture and replace it with something newer, faster, better, right? Let's just keep this simple, because the world in which we work is very complex, convoluted, complicated. So in order to master that world, you've got to learn how to master simplicity. Okay, what's the legal issue in Regina v. Faulkner? I'm going to use a whether, when format to identify my issue statement. Whether, when. Remember, last videos we talked about an under, does, when format for drafting legal issues. Now we're going to play with the whether, when. So here's the legal issue in Regina v. Faulkner. Whether a defendant can be convicted for an accidental act, which is a crime in and of itself, when the accidental act occurs in the process of committing another crime. Got it? Right? So what's the question? What is the thing that we're searching for an answer for? We've got 2 crimes going on here. And the question is whether a defendant can be convicted for the accidental crime, knowing that it in of itself is a crime, when the accidental crime occurs in the process of committing, for Regina v. Faulkner, the felony. Got it? All right, let's jump in and let's answer the question. What are some of the key facts of Faulkner? Faulkner is a seaman. He's on a ship. They're at sea. The ship has cargo. Some of the cargo includes rum, sugar, cotton. Faulkner intends to steal the rum. His mental process, his guilty mind is saying, I'm going to steal this rum, okay? I know it's not mine. I know it belongs to someone else. I know that taking from someone else without their permission is a crime, and dag nabbit, I'm gonna do it anyway. So Faulkner bores a hole in the cask. The cask is the container that the wine is being stored in as it's being transported. Faulkner bores a hole in it, and he grabs a bucket or a cup or whatever he's going to collect his stolen rum in, and he allows the rum to run out of the cask into his bucket that he's going to steal the rum. So Faulkner steals the rum. He's not going to be greedy, though. He's not going to empty the cask. He didn't bore a hole in the cask and then just insert like a really long straw and just, you know, start to consume it until it was all gone. He's being consciously aware that he's not going to be greedy about it, but he's still committing a crime. Now that the hole is there, now that the rum has come out, now that Faulkner's got as much wine as he wants, he's going to go ahead and plug up the hole, right? And he goes to plug up the hole, but he realizes it's much harder to stick something precisely in a hole to plug it than it is to just bore a hole in something, right? You don't really need to be able to see a lot to do that. Well, it's dark because the rum is kept in the storage bin that's probably under the ship and all of that stuff, and he can't see. And so what does Faulkner do? He needs some light. Well, how does he get the light? He lights a match. And when he lights the match, kaboom, wait, I mean, it didn't really go kaboom, but the rum lit fire. Alcohol burns, okay? So alcohol, the rum started to burn. He got burned on his arm and his neck. The ship caught fire, and lo and behold, the ship is destroyed. What was the crime he sought out to commit? That was the crime of theft, the theft of the rum, which is a felony. Got it? Knowing he was purposeful. That was his conscious objective, right? To steal that doggone rum. He was going to have a party of one. In the process of committing the act necessary to complete that formula for criminal liability to attach to Faulkner, he accidentally burns down the ship. He accidentally burns down the ship. Faulkner was charged with arson for burning down the ship. And this is what the charge read. Faulkner feloniously, unlawfully, maliciously burned the ship. Recognize those terms? That sounds very common law-ish, right? Remember at the beginning of the video, I said, it doesn't matter if you're dealing in the common law or if you're dealing within the model penal code, general wickedness is not enough. Here it is, right? So Faulkner was charged with feloniously, unlawfully, and maliciously burning down the ship with the intent to deprive, intent, remember, intent goes to mens rea, with the intent to deprive the owner of the ship, which happened, and to deprive the owner of the goods and the chattels that were on board the ship, which happened. Yeah. At the close of the Crown's case, right? We know that this is a crown. We know it's 1866. We know Regina is Latin for the queen. So we understand where we are. At the close of the Crown's case, Faulkner's attorney actually moved for a direction of an acquittal. Does that sound like anything that you may have come in contact with, right? You asked for a directed verdict. Well, when do you ask for a directed verdict? You ask for a directed verdict when the other side, the side who brought the case, hasn't met their burden to establish by reasonable doubt all of the things that they're supposed to establish. And so basically you're saying, even if everything that the Crown said is true, that's not sufficient to sustain a charge against me. So can we all go home, right? And that, in essence, is what Faulkner's attorney argued. Based upon the evidence submitted, the Crown failed to sustain the charge of arson. Now, as it goes, the motion was denied. The case continues. Once both sides rested and closed their case, the judge charges the jury. We're familiar with that language. The judge charges the jury. The judge reads for the jury the instructions that the jury is going to use to determine what justice should be. Okay, so this is what the judge read. Although the prisoner had no actual intention of burning the vessel, oh my gosh, the judge is saying right here, clearly we agree, or there's no argument, that the prisoner had no mens rea as it relates to the crime of arson, but that's okay, no big deal. If you find the prisoner was engaged in stealing the rum and the fire took place as a result of the stealing of the rum, you're good. You can hold the defendant, find the defendant guilty of the charge of arson, right? Kind of makes sense, kind of, right? If you're doing a bad thing and you know that you're doing a bad, well, let's not categorize it as bad, let's say unlawful. If you're doing an unlawful thing and you know that what you're doing is unlawful and you proceed in your unlawfulness and you are successful in your unlawfulness, but by the same measure, something accidental happens, which is also a crime, why shouldn't you just be guilty because you were willing to do something and engage in unlawful behavior? Why not enough? Well, from a moral perspective, maybe it is enough, but this is not a class on morality. Oh my gosh, this is a class on legality. And the law says, no. We've got two different crimes. We have the crime of arson and we have the crime of the felony of stealing the rum. There needs to be a mens rea for both. And even if what if the mens rea is the same? Well, in this particular case, it wouldn't be the same. How do we know that in this particular case it wouldn't be the same? Because what do we know by the very few facts that we have? We know that Faulkner intended to steal the rum. We know that. That sounds purposeful, right? That sounds intentional, right? If we want to go to the common law categories, right? That's up there. That's way at the top. But everybody agrees that the burning of the ship was an accident. That's a completely different level of mens rea. Completely different level of mens rea. So the mens rea needed for committing one criminal act does not automatically transfer the mens rea to all acts that occur from the original act. Simply said, general wickedness is not enough. Here's a question for you to ponder. Why isn't it enough? Okay, now that you've pondered it, let's keep going. What's next? Here's an opportunity for you to ask your colleagues, your professors, me, questions if you have them. If not, we're going to keep going. And let's do another visual of mens rea with the model penal code. It looks like this. The amount of guilt matters, okay? Your mens rea for using the model penal code, that's going to break out into 4 categories. We've got the category of purposeful, knowingly, recklessly, negligently, understanding that each of these categories carries different level of culpability, right? What the Faulkner case just illustrated, what the Faulkner case helped us understand, what the Faulkner case explained to us, that you can't just pick one of these 4 possibilities and say that if there's more than one crime, all I need to do is pick one mens rea, and that's going to cover all of the associated crimes. Okay, let's go to another case that further illustrates and further explains that the different level of culpability matters. The different level of culpability matters. Let's turn our attention to the State v. Jakowski case. That's a 2006 case, State v. Jakowski. Again, we're going to set up the legal issue as a whether-when format. Whether the trial court erred by charging the jury to consider if the defendant was practically certain that her conduct would cause public inconvenience, then that was enough to charge her of the crime of intentionally causing public inconvenience, right? Just by reading that, just by the way you set the legal issue up, right? That's the power of legal writing. You can frame that legal issue in such a way that the response has to be whatever the answer is you want. That's the power, that's the magic, right? That's why we painstakingly choose our words. That's why we don't mix words. That's why we don't interchange words. That's why we are very intentional. We understand that as lawyers, the only superpower that we have are our words and our heart. That's all we've got to work with, yeah? So going back to State v. Jakowski, here are the key facts. Defendant was arrested during an anti-war demonstration. During the demonstration, the defendant did block traffic at an intersection. She and the other people that she was with did block traffic at an intersection. The defendant stood in the intersection praying and holding a sign that had some anti-war slogan attached. Law enforcement approached defendant and says, you got to clear the intersection. Defendant says, I refuse to go. The defendant is arrested and the defendant is charged with, pay attention. The defendant is charged with intentionally causing public inconvenience or annoyance. So I'm going to make sure everybody's awake because I'm going to go back to slide 15, right? So you're going to get a little woozy, but let's just wake everybody up. The defendant is charged with intentionally causing public inconvenience or annoyance, because the public inconvenience or annoyance crime is an intentional one. We are going to slowly but quickly go back to slide 15 and take a look at purposeful, right? AKA intentional. If the crime of public inconvenience is an intentional crime, the state, the prosecuting arm, has to establish that the actor's mens rea was purposeful. The state has to establish by the facts that it was the defendant's conscious objective to block that intersection. Got it? It was purposeful. Yeah? All right, so let's go back to where we were now that we've had a chance to actually look at the chart. Defendant is charged with intentionally causing public inconvenience. Here is where it all goes to heck. Here's a practice point. For appeals in criminal cases, the two reasons that you will find most often as the reason for an appeal in a criminal case is, number one, ineffective assistance of counsel. If nobody's told you, you're always going to be the problem. It's always the lawyer's fault. And number two, improper jury instruction. Here's an example, improper jury instruction, as was our last case, improper jury instruction. In the Jakowski case, the judge charged the jury and said, if the jury found that the defendant was practically certain, I'm not going to take you back to slide number 15, but we know, right? Practically certain is attached to the knowing mens rea. Conscious objective is attached to the intentional, the purposeful mens rea. What do you know from what you've learned is the problem? The judge told the jury all they had to do was to find that the defendant had a mens rea, a practical certainty that that intersection would be blocked. And that's not the case, right? With an intentional crime, the state has to establish more than practical certainty. Again, it's not tomato, it's not tomato. It really, really matters. The amount of guilt matters. The words that we choose matter. Our intentionality of how we structure our arguments, whether they're in writing or whether they're communicated orally, it all matters. Questions? Here's an opportunity for you to talk to your colleagues, an opportunity to talk to your professors, an opportunity, if I'm your professor, to talk to me. And that's bringing us to a close of video 3, Mens Rea, part 1. Let's take a real quick review. What did you learn today? We were introduced to the concept of mens rea. We learned that there is a difference between the categories of mens rea and common law and the categories of mens rea in the Model Penal Code. We learned that the 4 categories of mens rea in the Model Penal Code are purposeful, knowing, reckless, and negligent. We learned that each of those categories carries with it a certain level of culpability. We learned that you cannot transfer mens rea of one crime to another crime, right? And we learned that jury instructions have to be very, 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 very clear and ensure that you're not just using words loosey-goosey, because if you charge the jury to find a lower level of culpability, right? A level that is lower than what the crime charge requires, you've got reversible error. That concludes video 3, Mens Rea, part 1. I hope it's been helpful. I hope it's been fun. If you have any questions, feel free to reach out at any time. I'll see you at the next video.